Good afternoon, everyone, here in Washington, D.C. Good morning to those of you on the West Coast and elsewhere across the country. Thanks for joining us today for our program entitled Somebody's Watching Us, Considerations for Nonprofits Operating Under Increased Government Scrutiny. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. As many of you know, this program is part of the monthly series that we've been doing for about 4.5 years now on a wide variety of different nonprofit legal and related topics. Today's program is a particularly interesting and exciting one for me. It's an area that I've always been personally very involved in, and I'm thrilled with the speakers that we have today for today's program, which I know you will be as well. We have a great crowd gathered here in Washington, D.C., and I think we have close to 300 registrants around the country for today's webinar, so clearly a lot of interest in today's topic. Few logistical issues first. First off, for those of you who are part of the Trade and Professional Association community, Certified Association Executives, these programs are eligible for CAE Continuing Education credit. Upcoming programs that we have scheduled, we have 3 scheduled. Actually, we're filled out for the balance of the year. On October 15th, our program is entitled Thriving Amid Turmoil and Change, What All Nonprofits Can Learn from Nonprofit Turnarounds. A terrific program with myself moderating the program and 2 outside speakers who I think you're really going to enjoy. A terrific program, not so much focused on legal issues, although there certainly are a lot of legal implications that I'll be discussing, but a really interesting program that every nonprofit can benefit from. On November 17th, a very hot button issue in the nonprofit legal and employment community and the labor and employment community generally. The U.S. Department of Labor's proposed changes to the Fair Labor Standards Act white-collar exemption criteria, what nonprofits need to know about the current rules, where things are heading, and how to avoid employee classification traps and pitfalls. Maybe perhaps the longest title we've ever had for a program, which I'm usually not a fan of. Nonetheless, it is going to be a really interesting program, and it's not only going to be focused on what the DOL has proposed and what that might mean for nonprofits, but it's also going to be a great refresher on the rules generally, which is something that just about every nonprofit that I've experienced can always use a refresher on, and it's a very complex area that's easy to get tripped up in, and I know you're going to benefit from that program. A couple of terrific colleagues of mine from our labor and employment group who work regularly with our nonprofit clients will be leading that program. And then finally on December 10th, another very, very hot topic these days when you can't seem to escape in the mass media, in the nonprofit world, and elsewhere, privacy and data security, best practices, common pitfalls, and hot topics for nonprofits. Again, 2 of my colleagues will be participating in that program with me. It's going to be a really fantastic one. So as always, we try to cover a wide variety of topics. And as those of you who are new to our series may know, we record all of these monthly programs and are all hosted on a YouTube channel, our nonprofit YouTube channel, so you can listen to the webinar and watch the PowerPoint slides at any time. On the last slide in today's PowerPoint is a link to where all of those recordings are housed, along with a link to the probably close to 1,000 different articles and PowerPoint presentations that we have on our website on every conceivable nonprofit legal topic, including many of those that we're going to cover today, searchable by topic area. Regarding today's program, those of you who are in the room have a handout, a printed handout book, a little thicker than usual because we did include, as well as the PowerPoint slides from today, quite a number of ancillary handout materials, articles on related topics, some of which we're going to be touching on today, some of which we really won't, but all of which are relevant to the subject of today's discussion. In addition, we did a program about 1.5 years ago that was really focused on what happens when your nonprofit gets hit with a government investigation. What do you do? How do you react? How do you respond from a legal, public relations, and other perspectives? That program will be the follow-up email that all of you will get tomorrow that will include a link to today's program, also will include a link to that recording. If you're interested in today's program, which is really focused on how to prevent that investigation from happening in the first place, I think you'll really benefit from that other program as well. Those of you who are in the room, feel free to raise your hand and ask questions at any time. And we'll pose those questions to our speakers. Just if I could ask you to wait for the microphone to come to you so everyone on the webinar can hear your questions. And those of you on the webcast, please pose your questions to me using the chat feature on the webcast software, and I'll pose those to our speakers. Depending on if we do have a lot of questions, we may need to move things along, so just bear with me as we may need to cut some things short. Now, let me introduce our speakers for today's program. To my immediate right is Yael Fuchs. Yael was kind enough to come down today to Washington, D.C. from New York City, where she works. She is Assistant Attorney General in the Enforcement Section of the Charities Bureau, the New York State Attorney General's Office. Yael conducts and oversees investigations and litigation of violations of New York laws governing nonprofits and their agents, including breaches of fiduciary duty and fraudulent solicitation. Recent matters that she's been involved in include settlements with 3 Long Island-based charities, their fundraiser and their accountant, and a special proceeding brought against a Brooklyn-based charity and its accountant. You may have read about those in the media, and Yael's been at the center of those enforcement actions. She also works in special projects involving nonprofits, including the Attorney General's oversight of disaster relief charities after Hurricane Sandy. She's also part of the adjunct clinical faculty at Cardozo Law School. Prior to joining the AG's office, she was a litigation associate at Paul Weiss in New York. She also served as a foreign law clerk at the Supreme Court of Israel, and she earned her JD from Columbia Law School. So in other words, she's a real underachiever. Yeah, I was just thinking that, Eric. I definitely should have introduced you first. To my far right is Eric Berman. Eric is a relatively new colleague of mine. How long has it been? About a year? Yeah, just over a year that Eric's worked with us. He's been a terrific addition to our firm and works very closely with our nonprofit group, not only on governmental investigations and enforcement action and litigation, but also on the counseling front, particularly when it comes to advertising and marketing issues. Eric's practice primarily involves counseling, regulatory advocacy, and litigation defense in the area of consumer protection and antitrust. He represents large companies, trade associations, charities, and others for the Consumer Protection and Competition Bureaus of the FTC, the U.S. Department of Justice, Antitrust Division, and State Attorneys General. He's assisted a wide range of clients in advertising matters, and on numerous occasions he's been retained by insurance carriers to defend targets of high-stakes and contentious FTC and state law enforcement actions. Both of our speakers have a lot to contribute to today's program. I'm really looking forward to it, and without any further ado, I'll turn it over to Yael.
Thank you very much. Good afternoon, everyone. Thank you to Venable, to Jeff, and to Eric for extending this invitation. 2 preliminary notes. I'm here today in my capacity as an Assistant Attorney General at the New York AG's office, but all opinions I express are my own. Nothing should be construed as legal advice. There is some other IRS disclaimer. Second, the OAG, the New York Attorney General's office, is paying for my expenses to be here today. All right, that out of the way, I'm very pleased to be here today for this discussion on governmental oversight of nonprofits. Now notice I didn't say scrutiny. I appreciate Jeff's provocative title for the program. All of the radar and the target business makes us sound very tough.
We did have to go back and forth quite a bit on the title until we settled it.
But at the risk of undermining this aura of toughness, which of course I accept and hope to live up to, I'm proposing a different title. In fact, let me make sure. Excuse me just a minute as we figure out the PowerPoint. There we go. Now next. I'm proposing a different title. I'd like to call it the Fitbit effect. Trademark, copyright. Improving behavior through effective government oversight. Now, of course, we at the New York AG's office are a law enforcement agency. We take that role very seriously, and we're proud to be part of taking charity regulation into the 21st century. An important part of our role, however, and one that we believe complements our traditional law enforcement function, is to promote a professional, accountable, and self-policing sector. Thank you. Sure. Our office strongly believes in this dual role. We rely on the sector to self-regulate by having in place effective internal controls, a word that you'll hear a lot today. And we rely on the bar and other gatekeepers, especially auditors and accountants, to promote compliance and best practices. I'd recommend to you all a settlement that was just filed, I believe, yesterday by the SEC against an accounting firm, BDO, that I was very happy to see in terms of the SEC also pushing this idea of the importance of gatekeepers, the importance of auditors, fulfilling their duties, their professional responsibilities, and I'll talk a little bit about that. So 2 takeaways overall. Yes, we are watching you. You are in a regulated industry, but we want to work with you. The sector is just too important. The work that you all do is just too important, and regulatory resources are too scarce for us to do it alone. There we go. So you hear these words a lot: compliance, internal controls, governance. One of my goals here today is for our presentations to flesh out your understanding of these concepts. Now, these concepts may be familiar, very familiar to a lot of you, in which case it'll be a good refresher. I think we are strong believers that internal controls are not something that you put in place and forget about. It requires, daily monitoring, daily attention. I will also give an overview of what we do as a state charity regulator. I assume that most of you here in the room and watching the webinar online may not have had much contact with your friendly state charity regulator. That's probably something you'd like to keep it that way. And finally, because we are not yet in a perfect world where all nonprofits function perfectly and regulators are obsolete, I'll also be talking about some best practices in the event of an inquiry or investigation. So with that, let's get started. A quick, refreshing definition. Internal controls are the policies and procedures that protect the assets of an organization, create reliable financial reporting, promote compliance with laws and regulations, and achieve effective and efficient operations. That comes right from a guide that our office put out. A quick plug: there are lots of useful guides on our website at charitiesnys.com.
And then, let me interrupt for a second. I should have introduced Elle by saying that her office, the Charities Bureau at the New York Attorney General's office, is, I think, largely regarded as probably the most active and proactive Charities Bureau of any state attorney general office, including in the area of giving proactive guidance and advice and counseling, including her participation in today's program is a great example of that. And so while the laws that Yael's office enforces are specific to charities that are incorporated and operating in New York, what they do often has effects well beyond New York and nationwide, some of which we're going to talk about today.
Thank you, and I'll try to make my talk not overly New York specific. You'll hear some references to New York law, but I understand that this is not a New York audience. So effective internal controls go beyond just having a policy. As Jeff mentioned, I just started teaching a class at a law school in NYU, and the students brainstormed ideas for a regulatory investigation, training the regulators of tomorrow. One of them suggested an investigation to see if hospitals are complying with laws governing how they collect payments from low-income patients. So we then brainstormed, what documents would you expect to see if you were testing whether this policy was in fact being implemented? What records, what proof of training? Because of course there's a big difference between having a policy and implementing a policy. So let's talk quickly about what may happen when there are failures in internal controls. 2 years ago, your hometown paper, the Washington Post, ran a fantastic investigative piece called Inside the World of Theft, Scams, and Phantom Purchases at the Nation's Nonprofits. And our host today, I will commend you all to primers that Venable put out after this article came in helping charities to identify and prevent fraud.
Yeah, and a lot of those are actually in your handout materials today. That's sort of probably most of the pages in the handouts are devoted to kind of proactive guidance on how to prevent and detect fraud and embezzlement in nonprofit organizations. It's a topic on which we've spoken and written a lot. And we actually had both of the co-authors of this series at different times as co-panelists in sessions like this at our office. And they really did an amazing and insightful job at uncovering some incredible things they found in nonprofits through simply reviewing Schedule O to the Form 990 that's filed with the IRS. But most importantly for everyone here today, it's important to take away kind of the lessons learned from that investigative series. How do you avoid making the next series that comes out? And how do you prevent these things from occurring in your organization?
Right. So as Jeff said, the Post reporters reviewed the annual IRS filings for nonprofits and identified those organizations that reported what's called a significant diversion of the organization's assets. Now, on one hand, this was Christmas in October for regulators. On the other hand, some of the findings really made you want to cry, pull your hair out, fill in the blank. The Post put together a database of the explanatory information that some of these organizations reported in their Schedule O, and I read over some of these explanations because as a regulator I read Schedule O's for fun. And so I wanted to share a few with you. Here's one. The custodian of the investment pool did not invest the funds and stole the remaining monies under his custody. Now, this one is an excerpt from the report of the independent auditor that came in after the charity discovered that the executive director had embezzled. So they begin, the board of directors is the oversight group for the company. Yes, okay, good start. It consists of volunteers from various walks of life and includes no members with a financial background. Not very uncommon, very common, but already a bit of a red flag. The board of directors, we believe, was intended to meet at least once per month. For various reasons, this didn't always happen. People are busy, The board of directors averaged approximately 8 meetings per year for 2008 and 2007, 2008. The minutes of the meetings contain no financial presentation. This was my favorite part. The board president explained to us that on occasions when a financial report was requested, the former executive director became upset and provided only sketchy information. Not a great sign. Not a great sign, people. And we laugh, and yet many of you are probably familiar with the phenomenon that we refer to as founder syndrome, where the executive director may be a strong, charismatic, highly effective leader, and it's difficult to oversee his or her actions. Difficult but not impossible, and in fact, your legal responsibility. Another one. The agency experienced an extraordinary loss of $161,000 resulting from a cybercrime in which funds were diverted. I thought that was nice just because of the word cybercrime, brings it up to the 21st century. I believe there might have been one more where it said that the program manager issued checks totaling approximately $90,000 to a fictitious subcontractor for alleged home repairs. So things like this will happen. The world is not a perfect place, and bad things happen to well-meaning organizations. Again, Venable's talk on what happens at a crisis, I think, was a very useful one. Sometimes the crisis is brought about by conditions outside of your control. Sometimes, but not often. If you live in Florida, you best prepare for a hurricane. or in New York or in DC for that matter. The point is that organizations that are prepared and that have conducted a risk assessment and that have functioning systems in place are less likely to suffer long-term damage and are more likely to be able to continue their mission. I want to say one word on this concept of a mission, which is all important, to all of you. Every once in a while we bring in somebody in the New York AG's office, most usually in the area of alleged or suspected fraudulent solicitation, and I hear nothing about the mission. They come in and their concern is justifying what the solicitation said, et cetera, et cetera. When they come in, and at no point do they say, okay, we get it, we're under investigation, we have to go through this, I don't agree with all of your conclusions, but while we're doing this, I've got kids with cancer that we need to support. I have homeless women that are waiting for their assistance. And of course, if we don't hear that, that's a really big red flag.
And I think at the same time, it's also what do you do and not what do you say, because we've both seen examples where board members, maybe not the most sophisticated people in the world, say, but I do really care about these victims or these women or these cancer survivors. Okay, but what did you do to make sure that the money was getting where it needs to be? So it's both. It's back up what you say and say it. Of
course. When they come in and say that, I don't mean that it's a sufficient excuse. I mean, I would expect that as you're undergoing any sort of governmental investigation or inquiry, in the forefront of your mind, not even in the back of your mind, is, how do I continue the mission? How do I make sure that this isn't going to derail the mission? And if you tell us that, chances are we're going to be more than willing to work with you to make sure that the burdens of the investigation, the potential reputational risk of the investigation is something that doesn't jeopardize your mission. So with that, a quick introduction, overview to the New York AGs Bureau. Again, I understand this is, we're an office that you may not have contact with, but every state does have some sort of regulatory agency that oversees nonprofits. Some charities don't realize that they are in fact in a highly regulated sector.
And just to clarify, there's a lot of folks here in the room and on the webinar who work for nonprofits that are not charities. And in your office, and correct me if I'm wrong, but your office, even though it's called the Charities Bureau, has jurisdiction over all nonprofit corporations that are incorporated in New York, and then to the extent that organizations are soliciting funds and conducting certain other activities in New York are also subject to your jurisdiction.
Yeah, that's a very good distinction. Thank you.
We have a lot of, for instance, trade and professional associations and other organizations that certainly would not consider themselves charities, do not solicit charitable contributions, are not tax-exempt under Section 501c3 of the tax code, but are still subject to the jurisdiction of your state's laws and in every other state, wherever your organization is incorporated, regardless of where you're located. That's generally the state attorney general's office that you need to be most concerned about, because that's the one that's always going to have direct jurisdiction. In certain instances, you can also be subject to other states' jurisdiction depending on the nature of your activities. And some states, like California, have a greater reach than others in that regard, but always pay closest attention to the attorney general for your state of incorporation.
In New York, the Charities Bureau has 4 sections. The registration section handles annual registration and filings. The transaction section has responsibility under our law to review and approve certain transactions like the sale of assets, mergers, and dissolutions. The trust and estate section protects the public interest in charitable gifts and bequests contained in wills and trust agreements. So they get involved when someone leaves an indefinite amount of money to charity or leaves assets to unnamed charities. So those of you who are involved, especially with museums, large cultural institutions, or any other organizations that would receive bequests may have some interaction with the T&E section in your state attorney general's office. And the enforcement section carries out investigations and affirmative litigation. We see our job as the preservation and recovery of charitable assets through public education, investigations, and legal actions. A lot of people ask how we get our cases. They are generally received through complaints. Those may be from a member of the public. Those may be from an insider at your organization. Referrals from other agencies, the news and the media, a review of annual filings, and I'll talk a little bit about that. I'm sure all of you are familiar with the Form 990. It contains a treasure trove of information. As we move to a more digitized and transparent 990, your state regulators will be that much more empowered to do data analysis and to look for patterns, because that's where we really find the red flags.
You know, it's great to hear you say that, because we've been counseling our clients for years now, and even more so after 2008 when the IRS overhauled the Form 990 to require a lot more information and a lot more disclosures. And now with electronic filings and just greater and easier accessibility to the 990, we've always known that it's obviously of great interest to the IRS and the state tax authorities, but it's become increasingly of interest to the media, to groups who are perhaps on the opposite side of your aisle, or your industry, or your profession, or your cause, and certainly to state regulators like state attorney general's offices. And it's so important that you not only put accurate information in the 990, that the numbers are accurate, that they're appropriately tied to your financial statements, but that you use the document to fully and comprehensively describe your activities, why you're engaging in certain activities, why you're structuring things in certain ways. Use the schedules that are available to expound on things, to positively tell your story. And if you have things on the 990 that are red flags, take the time to explain those. Those will be so important in helping convince people like Yael not to look at your organization as a target, but perhaps to look at the next one who didn't do that.
Right, and I would say to that effect, make your auditors and your accountants work for you. You know, there's a term that I've learned in this field, and maybe it's common knowledge, SALLY, which is same as last year. Make your auditors do their job. The form should not be identical year in and year out. So, you know, Jeff, you're exactly right that it is of interest to us. You know, I'll share a little bit of my day-to-day. We get a complaint. I get assigned a matter. You know, before we go out and issue subpoenas, what do? I look to see, do we have any historical complaints about this organization? I do some Googling. Okay, no big secret there. And then I'll start looking at the 990, and I'll look to see, is the organization A, up to date on its filing requirements? Are there repeated problems, repeated deficiencies that we see? And then we start looking deeper into certain areas of the 990.
And it's also a great point in that historically, and still to this day, many organizations have the 990 prepared by the auditors who are doing the audit of their external financial statements, obviously working with the in-house staff and the finance and accounting department, CFO. But in the past, historically, that's where it stopped. And it was largely viewed as just a financial document. So the auditors and the accountants and the finance people prepare it, but really others were not involved in it. And what we're seeing now as a best practice is not only getting your attorneys involved in reviewing it, which we do more and more and more, and not just reviewing it from a legal and tax perspective, but from a broader perspective as well, but also having other staff in the organization, the program staff and others reviewing it and making comments. That's becoming more and more of a best practice. It's still not the norm. We still see so many organizations. The 990 is always prepared by the auditors at the last minute. It never fails. And so there's always a rush. We get it on our end. Can you please review our 990? But we need it back in 24 hours. And there's probably not a great opportunity to have other like key program staff, vice presidents and others review it. But it really is so important. If you give them the leeway to add and modify and fine-tune the 990, you can prevent a lot of problems.
When we talk about an enforcement action, we're not necessarily talking about a formal investigation. This is in the New York AG's office. An informal action can include a letter from the registration section identifying a deficiency in a filing, and that would just give you an opportunity to correct that deficiency. If an organization is the subject of a criminal action going forward and you're under our jurisdiction, you can most likely expect a letter from the New York Attorney General asking what, if anything, you've done to understand the scope of the problem and to remediate the situation. So those deficiencies, that we saw in the Washington Post investigation, when we see those, we're going to be asking, what, if anything, have you as the organization done to look into why the CEO was able to write invoices to a mysterious subcontractor that nobody had heard of. We may also ask you to provide us with information in connection with a special project. We have surveyed breast cancer charities that partner with for-profit corporations and cause marketing, all the pink ribbon stuff. As Jeff mentioned, after Hurricane Sandy struck, we surveyed organizations that raised money in the name of Hurricane Sandy to ask how much was raised and how they were spending the money. This was one of my special projects, and for me it was a really powerful illustration of the challenges that organizations may face in a crisis. How do you continue functioning when you as an organization have got no electricity and your staff members can't get into the office? Are you going to provide the types of assistance that you haven't provided before? And what are you going to do with all that money? We saw organizations that were flooded, no pun intended, although I should have caught that, with money, and they didn't have the capacity to spend them, or they didn't have systems in place to differentiate between restricted and unrestricted funds, which is something that has to be on your radar screen. They also didn't have the checks in place to prevent the diversion of assets. You know, you have way more money coming in than you've ever seen. That's going to give an opportunity, unfortunately, for staff, volunteers, to run away with some of that. Or fraud from people seeking assistance. If you're going to start making grants after a disaster, that's wonderful, that's beautiful. But do you know what you're getting into? And do you know the procedures that you have to put in place, some of the best practices to prevent fraud? We in the New York AG's office can also issue subpoenas for documents and for testimony under oath. We can do that in the investigatory phase. And our authority to issue the subpoena is a fairly broad one, and I think most states share that very broad authority. There just has to be a reasonable relationship between the material that we seek and the topic of the investigation. And we've gotten more aggressive in moving to enforce subpoenas when our targets don't comply. In New York, the AG also has broad powers to get injunctive and other relief to stop what in our code is called repeated fraudulent or illegal activities. And this is important as an enforcement attorney. For us, fraud is defined differently than common law fraud. Common law fraud, for those of you who aren't lawyers, requires intent and reliance on the fraudulent representation. So the person making the fraudulent misrepresentation has to have intended to defraud, and the person who gave the money has to have relied on the fraudulent misrepresentation. Well, as an AG, we don't have to prove those two elements, which means even if you didn't mean it, it can still be fraudulent. So you need to be very careful about your public-facing solicitations and representations.
And I would say generally, we've always known this, that In a lot of different areas of law, certain enforcement agencies, federal agencies, state agencies, have limited authority. They can only enforce the laws that you may expressly be violating. So, for instance, the IRS has broad authority to enforce the tax laws. There's a lot. They're not the broad general enforcement authority for nonprofit organizations. They can only enforce violations of the tax law. The IRS has gotten more aggressive in recent years in trying to promote good governance by asking certain questions on the 990 and whatnot. But they have no authority to do anything to a tax-exempt organization that checks no to those boxes and doesn't have kind of best practice good governance policies in place. And the same thing goes for so many other federal and state agencies. But one thing we've always known is that state attorneys general, particularly in the state where you're incorporated, have very broad authority, much broader than any other agencies I've ever seen, federal or state level, to enforce so many things that a nonprofit may be doing or failing to do. And so it's, of all the agencies out there, it's perhaps the one you have to be most concerned about, because they're not constrained by a very narrow set of laws and rules that they can enforce. And if they see anything that seems improper or inappropriate for a nonprofit organization, the odds are they have enforcement authority to do something about it.
Well, and of course we tie that to our statutory authority. We don't have the resources nor the desire to go on fishing expeditions, but the concept of fiduciary duty, which you're all familiar with, is a very broad one.
Good question.
Just wait for the mic, Steve.
Hello. A quick question on your role. Do you have any powers, or do any of the state agencies have any powers to question whether the 501c whatever is deserving of that status, or is that all just completely, if you take it for granted, if the IRS issued it, that's good?
As a general matter, we take it for granted. It's the IRS's province. However, we can get at that in other ways. So if you are not, there's laughter in the room, and I guess that just speaks to our broad enforcement authority. But I think we can get to the heart of the matter. If you, and just as the IRS is the one that enforces the concept of private inurement, that's not a state AG concept. But if there is a tremendous fraud or self-dealing, or the charity is not acting consistently with its mission, those acts all violate various state provisions.
And there was actually a case maybe 20 years ago, 15 years ago, that I think regulators would think of as the best and juiciest fact pattern that you could hope for. It was a charity that contracted with a for-profit fundraiser and gave the for-profit fundraiser 90 cents of every dollar that came in. And the IRS tried to revoke that charity's tax-exempt status. And by the time it got up to the Seventh Circuit, Judge Richard Posner, who's one of the more, you don't know a lot of judges by name, but he's one of the few that you do, and he said, look, it's not private inurement. They didn't drive a good bargain, and maybe desperate charities should be encouraged to fold rather than give so much power to the fundraiser. But he denied the revocation. So I don't think you see a lot of IRS actions, and so the runaround, not that the government's overreaching, but but the runaround is to allege things like fraud, and occasionally you'll bring in the FTC. But really, as Yael and Jeff have been saying, it's the states that are on the front lines.
Just a little postscript to that. If we're talking about the same case that was the United Cancer Council case,
yes, we are.
I think it was 85 cents of every dollar raised went to the professional fundraiser. The rest went to the charity. The court did find that there was not enough to uphold a finding of private inurement because the fundraiser was not an insider, didn't have an ability to exercise substantial influence over the organization. They weren't an officer, director, employee, etc. But if I recall properly, he did find a finding of private benefit, which is a much broader violation that basically was saying too much benefit went to the private company, the fundraiser, not enough to the public. Therefore, he upheld revocation on different grounds, or he might have sent it back to the IRS and they made that finding. But regardless, it's a good illustration of how a 501c3 organization can violate the tax code, because the private benefit doctrine is only applicable to C3s. But it's also a good reminder of how in that situation a state attorney general would certainly have broad authority not only to potentially revoke the nonprofit corporate status of the entity, but to force repayment of funds and things like that. So in that case, in the finding of private benefit, there's no intermediate sanctions or other things where you can force the repayment of those funds. There's nothing the court could do from a purely tax law perspective. But if the relevant state attorney general came in, they actually could bring an action and force a repayment of those funds, and you do that quite a bit.
Right, and what we would have to do, as I said, would be, to connect it with the issue most likely of a breach of fiduciary duty. We would go in a case like that, and I'll be talking about these cases in just a sec, and ask first why. Why did you enter into this contract that gives your professional fundraiser 85 cents on the dollar? Where was the board? What other contracts did you consider? What other methods of fundraising have you considered? Now, nonprofit corporations, the boards are protected by the business judgment rule, just as for-profit corporations, but the business judgment rule requires the exercise of good faith. We would also ask, are there any relationships between the members of the board and the for-profit fundraisers who are making 85 cents on the dollar?
A question up here in the front. And then after this, we're going to have to keep it moving. John?
How does a C3 know whose jurisdiction it falls under? New York, New Jersey, District of Columbia, especially in the electronic age when you may be sending a solicitation beyond your membership, because a complaint could be filed with New York and you had no intent of soliciting in New York.
That's absolutely right. The question of jurisdiction can be a complicated one. For New York, if you are incorporated in New York, if you're doing business in New York, if you're holding charitable assets in New York, or if you are soliciting in New York, you are subject to our jurisdiction. When it comes to Internet solicitations, there's guidance, which is non-binding, but it's guidance known as, I believe, the Charleston Principles, which provides that just sending out an Internet solicitation without more specific targeting of that state isn't sufficient to bring you into the jurisdiction of that state.
Unless you're receiving repeated and substantial contributions from residents of that state. That's the other way that you could be subject under the Charleston Principles to the jurisdiction of that state.
So in the event of Hurricane Sandy, where thankfully we had organizations across the country raising funds to help victims of the hurricane, many of which were in New York, we did look to see whether they were specifically targeting New Yorkers. So I want to talk for a minute about fraudulent solicitation, which it overlaps, not completely, with the issue that Eric brought up of high fundraising fees. Fraudulent solicitation is a major target of the New York AG's office. It's been a hot topic in the press lately. There's the Cancer Fund of America case, which Eric will talk about in a little bit more detail, pending litigation, so we can't go into too much detail. There is the National Children's Leukemia Foundation case in New York, which I recently filed. These get a lot of attention, but they're outlier cases. These are cases of charities saying things like, we have a hotline of trained domestic abuse advisors when no such hotline exists. Or we provide veterans with life-saving support goods when, in fact, you are sending expired vitamins. Most likely no one in this room is ever going to face a fraudulent solicitation investigation, but they're important for at least 3 reasons. 1, they divert charitable dollars from among the neediest in our country. 2, fraudulent solicitation often targets vulnerable donors, especially the elderly. I'm sure you're all familiar with, your parents or grandparents receiving harassing phone calls from charities or from professional fundraisers on behalf of charities. And 3, and this is where I believe it should be important to all of you, they decrease public confidence in the sector as a whole. Every time we bring one of these cases, the other charities that we work with say, you know, good work, guys. You know, thanks for bringing down the bad guys, but man, you know, now we all look bad. And that's certainly not our intent, but we are aware our response to that is to try to shut them down, to try to end that practice. So since we're talking about that, what are some red flags? There's a lot of attention in the press given to high fundraising fees. High telemarketing or fundraising fees alone are not indicative of fraud. You can have a contract where the professional fundraiser keeps 85–90%. The Supreme Court has held that states and the federal government may not regulate professional fundraising by percentage. It's protected speech. There may be legitimate reasons. Maybe some of you can share them with me. No, but seriously, as even the Supreme Court has said, there are instances where you're prospecting for new donors. There are instances where the call is really a call to action, a legitimate call to action. There are instances where you are fundraising for an unpopular cause, and it's just that much more expensive to do your fundraising. That said, when you look at charities that use high-cost fundraisers as their primary or sole source of fundraising, as opposed to one part of a more diverse portfolio of fundraising, over a long period of time, so not just in the startup phase where maybe you're hunting for donors and that's expensive, we find that the likelihood of other violations increases substantially. So when we go after those charities, we're not going after them because of the high fundraising costs per se. We're going after them because the combination of these factors suggests that something else is going on. Best case scenario, the board is asleep at the wheel and not really thinking about fundraising. Worst case scenario, they've been captured by professional fundraisers who are using their name basically as a vehicle for personal enrichment. Other red flags, very often these organizations have sound-alike names. We often, I don't know if it's a joke, it's probably not funny, but we talk about, the 3 hats or the 3 buckets. So I could pick out from one bucket federation, and from the next I could pick out something that people really like or really don't like cancer or puppies. And from the 3rd bucket, Association of America, which is not in any way to say that the Association of Puppies with Cancer of America is a problematic charity. But very often when it seems that they may be banking on a legitimate name to cause confusion, especially among elderly donors, we're going to look closer.
And of course, as Eric knows well, there are other remedies in situations like that, and we're often representing kind of the legitimate charity or association that kind of the scam charity is trying to play off of. And there are other avenues like Section 43A, the Federal Lanham Act, and other kind of federal trademark-based remedies that you can utilize to pursue those sorts of charities. But certainly the state AGs have a lot of authority there.
I'll just mention quickly that we also look in these cases to see if the charity has a significant gift-in-kind program or is using joint cost allocation very aggressively. Gift-in-kind, as you may know, is the acceptance of goods rather than money, and then the distribution of those goods. That can be an important, essential part of a legitimate charities program. And we don't look askance at it per se at all, but it's subject to abuse because the valuation of these goods is very much subject to abuse. And what we're concerned about is that you have a sham charity that is inflating its program expense numbers and its program revenue numbers through the abuse of gift in kind. We're also concerned about the abuse of joint cost allocation. Again, a legitimate accounting mechanism. If you're sending out a fundraising appeal and it's also a call to action, you may well be able to allocate some of those expenses to program expenditures, to awareness raising or advocacy. That's completely legitimate. Again, very much subject to abuse, and we're concerned about charities that are using that to mask high fundraising costs.
So just to expound on that point, just to make sure everyone understands what Yael's talking about, charities in the fundraising area are always trying to push their administrative and fundraising costs down. It's viewed as a more positive potential beneficiary, a greater potential donee of charitable contributions if those costs are lower. So that's what Yael's getting at. But I think another important point to take from this is it's not just fraudulent solicitation. And as the New York Attorney General's guidelines on the breast cancer charity commercial co-venture issues points out, this is not just about fraudulent solicitation. This is about sometimes misleading solicitations, things that can potentially apply to all of those charities that are represented here in the room and on the phone, and things that we see all of the time from some of the country's biggest and largest and well-run and best-meaning, best-intended charities. With the kinds of words you use in your solicitations, if you're not being clear, if you're using, for instance, that the company that's saying a percentage of your purchase is going to be donated to this charity, but if you're really only donating net proceeds, your net profit, a percentage of your net profit after costs, but your expenses, but you're not being clear about that in the solicitation, that can be very problematic because it may look like you're donating 5% of every dollar that's purchased of your product to the charity, but in the end, after you allocate expenses to it, you're really only donating, half a cent of every dollar, or not being clear if there's a minimum contribution or a maximum on the contribution that the for-profit company will pay to the charity. Or if you're running a charitable match program where you say for every dollar that the public gives, this company is going to match it dollar for dollar, but it turns out the company already gave the contribution a long time ago and there really is no match. There's a lot of things like this that we see this happen all the time. You laugh, people laughing in the room, but it really does happen all the time to the best, most well-meaning charities. And these are the kind of lessons that you can learn not only from some of the really bad actors out there that your office is obviously most interested in pursuing, but these are things that everyone needs to pay attention to.
There's actually, it's becoming a form of weird comparative advertising among charities, even though they're not engaged in commerce in the traditional sense, I suppose engaged in competition for donor dollars, but chasing this artificially low overhead number. And I think, and I'm hopeful about this, and I think you are too, Yael, there's sort of some pushback on that, where even the Better Business Bureau and the Wise Giving Alliance are sending out letters to the public saying, don't believe this, and I'm using air quotes for those on the phone, overhead myth. Nonprofits should be spending to do good. There's also people, in the industry like Dan Pilata who go around talking about this, who I don't think regulators particularly care for, but they're making a point that you shouldn't run away from admitting to donors that no, not 100% of your dollar is going to go for that. Obviously, that can't be possible. Someone's manning the phone. Someone's leasing this space.
Yeah, I think that efficiency argument I think has been oversimplified on both sides. I think the watchdog groups and the regulators were hoping for a metric to make it easy for people, because people are always looking for who to trust, which charity should I give to, who should I trust, and it seemed like a good metric. And now, as Eric said, even the watchdog groups are backing away from that. And we, in the time that I've been there, we don't use it as a measurement. We don't choose our targets by where they fall on the efficiency rating. Again, I would just say, though, when you start scratching the surface behind highly inefficient charities, other statutory violations may be there. I will try to breeze through some of these next slides. Other common issues that we look at apart from fraudulent solicitation, Reporting violations, we're specifically looking at patterns of deficiencies, not, a one-off, one-year mistake. We're reasonable people. False reporting of your numbers. We take transparency very seriously. We use this information. The public uses this information. If it's not accurate, kind of defeats the purpose. Related party transactions or self-dealing are something that we look at very closely. Related party transactions, so having a deal with a member of the board or the executive director's brother, not wrongful per se, sometimes maybe to the benefit of the charity. But the New York not-for-profit law, as it was just amended, sets out specific steps that a charity needs to follow before you engage in a related party transaction. And I strongly believe that those are for the benefit of the charity. Before, the law said something general about, it needs to be in your best interest. Now we ask for comparatives. We ask that the board document whether or not you looked for comparatives. And I think that is very much helpful for charities. It's for your own protection, especially maybe if you are facing pressure from an insider who's also looking for a business opportunity to say, no, we are subject to these requirements. We have to go out and get bids.
Just two quick related points on that. First off, this has also become a very big issue for the IRS, for the Internal Revenue Service, for tax-exempt organizations. It's an area that they're increasingly focused on, both and upfront in the exemption application process and on the back end in the enforcement and examination process. The IRS also has multiple enforcement tools at its disposal, not just revocation of exempt status, but intermediate sanctions for 501c3 and C4 organizations that they can utilize in this area. And in addition, this is also an area where historically there's been a lot of communication between the IRS and state attorneys general offices. We saw it, for instance, to a large degree back maybe 5 to 10 years ago when there was a big crackdown in tax-exempt nonprofit credit counseling agencies. There were, the IRS did audits of virtually the entire industry, and many state attorney generals, including New York, and many others, Illinois, Massachusetts, and others, brought investigations and enforcement actions against credit counseling agencies where there was the people running the nonprofits also owned for-profit companies that were providing most of the services, and most of the money was kind of coming in through the nonprofit and going out through the for-profit that was owned and controlled by the same people. In those instances, there were a lot of referrals back and forth between the state attorneys general and the IRS. And to Stephen, to your question earlier, there is oftentimes a lot of referrals in that regard. So just because when you have a big IRS issue, you often have a state attorney general issue and vice versa.
And I'd like, if I may just for a second, to humanize the issue of related party transactions, because what we see very often is people involved in nonprofits, in charities, looking for additional profit avenues because they say to themselves, well, I'm doing a good deed. Most of my energy is spent for the public benefit. I'm not being paid as much as I would be if I were on Wall Street, so I deserve this additional opportunity. And that's kind of the psychological factor. It's not a defense from a regulatory point of view. We also see or have seen in the past efforts to paper over the diligence that you were supposed to do with these transactions. That's not going to do it. I guess the idea being that it's better than nothing. We'll hire some law firm and they'll, tick the boxes. We see that, to go back to my Fitbit theme, that's the equivalent of people, waving their arms up and down to increase their daily steps. So we don't look too fondly on that. It happens. Sometimes you're busy. The use of restricted funds, again, very important for those of you who get bequests or restricted donations, big issue in the disaster relief field. Diversion of assets, embezzlement is obvious. I want to talk for a second about imprudent investment. You may be subject to certain regulatory requirements in your state on the use of endowments. In New York, there has to be a written investment policy. You see a lot of problems, leading up to bankruptcy and insolvency that result from having an imprudent investment policy or overly relying on an investment advisor who turns out to be unscrupulous. So that's an area where you need to be really, really vigilant. And then the last one in this issue is the documentation of loans. This, for me, is a really important issue. You see it very often in religious organizations, in communities where deals are often made on a handshake, and maybe it's considered insulting to actually reduce loans to writing. What happens is then that loan is called, or the organization comes into money. In New York, the fact pattern that we often see is the organization then sells a piece of property. In the New York property market, that can be quite a windfall. And all of a sudden, everybody comes at you with their hand out because they made a purported loan, 5 years ago. And don't you remember that that gift was in fact a loan? So you're subjecting your charity or your organization to real potential exposure. Yes?
Does excessive executive compensation fall under your purview?
Absolutely.
Okay.
Excessive, under New York law, executive compensation needs to be set by the board. It needs to be reasonable. And there are a lot of best practices out there relating to executive compensation, the use of comparables, the good use of comparables, looking at organizations that are appropriate size, et cetera. We're running out of time. I can talk about this for way too long. So I want to skip ahead just to a few things. Best practices, maybe that got turned off. Keep going. If you're under investigation, what will we ask? We're going to ask questions that are backwards looking. Who is in charge of your compliance function? Now, these are in no particular order except for the first one, because that is my boss's favorite question. Who is in charge of your compliance function? You may not be large enough to have a compliance officer, but somebody needs to be aware of the applicable regulations. Somebody needs to be looking at your solicitations from a compliance point of view. Compliance can sound kind of boring. On the train up this morning, I thought, what about calling it your chief trust officer or your chief public trust officer? I don't know if that works. You can kind of think about that. We can workshop it. But because that's what we're talking about. It's not just the person, who's kind of like the accountant checking off the boxes. This is the person who is protecting your organization's reputation. Are you in compliance with your reporting obligation? How have you dealt with past complaints? Do you have a whistleblowing policy? What are your public-facing representations like? Do you have internal control policies? Is your board meeting regularly? Is your board meeting regularly? Are the meetings documented? Please have minutes. And how are you overseeing senior management, including compensation? We'll also ask forward-looking questions. Now that you're under investigation, what are you doing to solve the problem? How are you addressing it? Are you treating whistleblowers appropriately? Probably not the best practice is to come to us and tell us what a lousy guy the complainant is. Whistleblowers always have issues. There are always, vulnerabilities. Probably not your best defense. What have you done to identify the nature and the scope of the problem? Is it just that your executive director ran off with $90,000? Or maybe nobody was looking at her expense reports? And, you know, there are some textbook crisis, post-fraud types of checklists. Have you isolated the bad behavior? Have you gotten control of the accounts? Have you taken appropriate disciplinary or legal action? Have you implemented new policies or procedures? Have you disclosed to your board? We have organizations that are under investigation and it turns out the board doesn't know. Have you thought about the appropriate disclosure to your donors, to other agencies? Do you want to do an internal review, or do you want to call in some independent people? There's no one-size-fits-all answer here. We don't require external review, but something you need to think about. And then document retention, very technical, very important. You need to talk to an attorney about appropriate document retention policies. Fundamentally, we're looking to see what are you doing to preserve the value of the organization, to continue its mission, because that's what we want you to do. Thanks very much.
Would you recommend that they talk to any particular lawyers about document retention?
And Yael has included in her slides here some additional suggested reading. All of you here in the room have copies of this. Those of you on the phone the PowerPoint slides were included in the confirmation email, and all of you will get copies of all of this tomorrow in the follow-up email with the recording. With that, I'll turn it over to Eric.
Thank you, Jeff. And we're running a bit short on time, so I'm going to try to hit the high points without being duplicative of what Yael said, and nothing that she said is anything I disagree with, would wholly endorse. And for those of you who are physically in the room, I'm much more engaging after some cocktails, so come to the happy hour tonight, and we'll talk some more.
It's just a delay, Eric.
Understood. I was thrown off for a second. But you know, this issue of regulatory scrutiny, or if you prefer oversight, it's always been important, obviously, for everyone here, for everyone on the phone, and it has been a recurrent theme throughout, you know, the 4.5 years that Jeff has been putting on these fantastic programs. Part of the impetus for today's particular program was the announcement in May, and this is the Cancer Fund of America case that Yael mentioned. This was unprecedented. Okay, this was the Federal Trade Commission, and that's a screenshot of Jessica Rich, who is the director of the Bureau of Consumer Protection at the Federal Trade Commission, joining forces with every single state charity enforcer. Every attorney general, in some cases for, I believe, standing reasons, some secretaries of state. You had 58 plaintiffs in this case. And so, you know, I would talk about this case with some people, and they would say, oh, so how many attorneys general? All of them. All of them. So I was debating between, you know, whether to put up this quote. This was from the press conference announcing the law enforcement action, that this is an historic moment, or just putting up Joe Biden's quote about Obamacare, that this was a big effing deal. About 10 or 12 years ago, I recall the FTC joined with 30 or 34 states in some more targeted law enforcement and public education targeted against fraudulent fundraising. This far eclipses that. And I want to be clear about something, and we've said this throughout the day. Nobody is suggesting that anybody here or anybody listening in is similarly situated to the defendants in the Cancer Fund litigation. These are outliers. These allegations, the complaint is publicly available, is a murderer's row of things that you should not do if you're running a nonprofit. Everything that we've talked about, from donor deception, poor board governance, self-dealing related party transactions, falsifying or at least misrepresenting things on the IRS 990 form. We're not suggesting that that's everyone here, but when you this was an easy case for the media to latch onto, and there were some sensationalistic facts, and there was one defendant who gave the middle finger to somebody on CNN a few years ago, and that's what Anderson Cooper likes to slap on his show. But when you put all that stuff aside, you're left with what I think is a more important takeaway, which affects even well-meaning nonprofits and trade associations and charities, and that is that you now have precedent for federal and state coordination, the likes of which we've never seen. And this is a larger trend that regulators are beefing up their resources, they are getting the appropriations to increase staffing, and they are sharing information with each other more frequently and more efficiently. About 3 weeks from today, all of these regulators, I think you included, will descend here on Washington for the annual NASCO and NAG meeting. You guys know what that is? National Association of State Charity Officials, NASCO, National Association of Attorneys General, annual meeting here in Washington. I'm sorry?
I think it's a wild conference.
I'm sure it is.
I said it's a wild conference. I spoke at the last meeting here. I would call it wild, but it was definitely a fun group.
That was a joke, very much.
But it really is. I mean, NASCO's been around for decades, but these conferences get bigger and better every year, and the information sharing is more robust. And yes, they will talk about the cancer fund case, but they will share leads, the regulators will, on all manner of pending investigations. So I tend to think of this landscape as the new normal. And from the perspective of an outside attorney, my job is to help folks like you reduce risk. I often tell clients, I don't like to say yes or no, I mean, unless it's really obvious. Usually you tell me what you want to do, and I provide a risk assessment, and then you do what you want based on your risk tolerance. But we now have to handicap this a little bit and take into account this increased oversight. So I'm going to try to go through this quickly without repeating what's already been said, but I tend to think of this as, what if you were to hire us to do an internal compliance audit, or in what ways would it make sense for a nonprofit to be proactive and reduce risk in advance of an investigation, hopefully to the avoidance of one. I think regulators think that compliance is a top-down issue. And I mean, this is true for for-profits as well, of course, but particularly true for nonprofits. Who are your directors? Yael went through a lot of this. How many directors do you have? Are we talking about a small handful of friends and family who get together sort of informally? I think that regulators would like to see a larger, 7, maybe 9 or more robust board. The higher numbers reflect a greater diversity of experience, greater diversity of opinion, and I think are viewed as a good defense against groupthink and a good defense against that charismatic force of nature executive director that tries to treat the nonprofit as his or her plaything.
Yeah, it's become really important from an IRS perspective. The IRS really questions that, and it's not always. Sometimes it is. We had someone that came to us, wanted to hire us recently. I think after they heard my initial advice, decided not to hire us. He didn't want to have additional people on the board because he didn't want anyone to tell how much he could be paid in compensation. But then we had someone else who actually did hire us. Forming a new foundation, wanted to have himself and 2 family members, and they weren't going to pay themselves anything. It wasn't about payment, but he didn't want others to be able to tell him where the priorities should be and what they should focus on or not focus on. And I had to stress from an IRS, from a state AG, and other perspectives, that's just not the way to go. And one more story, this is all on the last week actually. Had a client yesterday who said, we don't want to adopt a whistleblower policy because we have 2 board members that we know are going to utilize that thing constantly every other day, and we don't want to have to deal with that. So do we really need a whistleblower policy?
It's amazing. I had a very similar experience, Jeff. Also in the past week, where a nonprofit called and started asking some preliminary questions and said, send me a bill. And I said, well, this is to get to know you, and I just want to give you some pointers. And the takeaway message was, so we can't do telemarketing? You can do telemarketing, and this is the compliance struggle that we face. Obviously gifts in kind are not per se illegal, or else we wouldn't have soup kitchens and used clothing donations. Telemarketing is not illegal. It's the abuse of those informational and fundraising techniques that are ripe for regulatory investigation. But some people don't hear that message. I'll repeat what Yael said. I always ask for written policies and procedures, and I don't just want to see that you have one, and I always check the metadata to see if you wrote it the day before you emailed it to me. But beyond having one, do you enforce it, and can you give me examples of maybe terminating someone who is engaged in a related party transaction, or do your meeting minutes reflect that the executive director doesn't vote on their own compensation, things like that. I know that if you're investigated, the government's not just going to take my word for it. I need to substantiate this, so you have to substantiate it to me. I want to see, if we're going to put things in broad buckets, I may have clicked too far, but I want to see what donors see, what the public sees, and what I know that regulators will ask for. And I apologize, I'm all over the place with this clicker. Here, this is perfect. We've talked about fundraising, so I'm not going to beat it into the ground, but I put diversity there. A common thread that you'll see, people were smirking and smiling and gasping at 85% or 90% going to a fundraiser. The common thread you'll see is that the charity is almost at the mercy of the fundraiser. They don't engage in any other fundraising. What else do you do? And we often advise that there's a very different risk profile between solely relying on fundraising, telemarketing in particular, and special events and walks and galas and dances and grants and things like that. And so I think that diversity is a good thing. We talked about auditors, and this is key. And I cannot tell you how many times I've had charity clients say to me, but we just got audited and we passed with flying colors. So what could possibly go wrong? Well, what did you pass with flying colors? Your auditor is looking for whether there might be material misrepresentations in the financials. They, unfortunately, are unlikely to be thinking of the entire forest and how donor solicitations weigh into all of this, and your advertising issues and antitrust. That's not a defense, and it's not going to carry the day when Yael comes knocking on your door. So I like to interview the auditor. Sometimes you get a very credible one, and I'm always thinking, who can I bring to a regulatory meeting if there is an investigation? Who has credibility? But I'm not just going to take it on faith that you passed your audit and so everything is fine. One last word is, people have asked questions about executive compensation. I actually put gift in kind and joint cost allocation underneath it, and what does one have to do with the other? Well, here's what. I really didn't want to cite case law. I cited one case just to make the point that a nonprofit can spend a few shekels to, if that's what it takes to recruit somebody, an executive director, that will make sure that the charity is functioning efficiently and in support of its mission, you can do that. And there's case law that is clear on that. Jeff was quoted the other day in Bloomberg about executive compensation in higher education. Sometimes you're competing even with for-profit competitors, but make sure that it's real apples to apples competition. So if you are an organization that has 12 employees and one location, and you give $800,000 a year in cash to recipients, but you are valuing $25 million worth of donated goods that maybe you've never even seen or taken a look at, and you send them off to Guatemala, and you say we're a $30 million charity, and you use that as the basis for setting your executive director's compensation. Well, what? It's okay that they make $400,000 a year. That's what other similarly sized organizations pay their executive director. Regulators are going to scratch beneath that surface, and they're going to look at how you're setting compensation, and it all comes together. If you do happen to be...
Can I make one additional point about executive compensation is we will also look at non-salary benefits, where you often see very large perk packages, severance packages, et cetera. And then again, on the human point, not something that somebody would explicitly say, the appropriate comparable for salary and perks and expenditures is not what your board members make. I find very often in New York organizations especially, and I'm sure here, where your board members may well be very wealthy individuals, and they're used to always going to the Four Seasons for lunch. That doesn't mean you should always be going to the Four Seasons for lunch.
It really has gone downhill, though, in fairness. So. It's not really a sign of abuse.
And we've talked a lot about nonprofit executive compensation here today. It's an issue that we cover quite a bit in these monthly programs. We have several recorded webinars on the topic. And just a quick plug, a colleague of mine and I are doing a free webinar for GuideStar on September 15th at 2 o'clock Eastern if you guys want to sign up and hear more about this topic, because it is a very important one these days.
Absolutely. So in 4 minutes, what happens if you do get a subpoena, an access letter, a CID, which is a civil investigative demand from the Federal Trade Commission? And I'll talk about the FTC in 1 second because we haven't really touched on it, and it is important, especially for the people in this room. Best practices. I cannot agree enough with Yael's point. Candor, transparency, honest. Doesn't mean you roll over, and it doesn't mean you do whatever the government says. But I have been privy to so many investigations, and as Jeff said, I've been at Venable for a little more than a year, but I've exclusively practiced in Washington, D.C. law firms that know how to talk to government regulators. And a lot of times I'll be dealing with co-counsel who is a litigator from the Midwest, and they're a very good litigator from the Midwest, but they have no idea how to talk to the government, and they come in and they're charging like a bull in a china shop, and it doesn't get them anywhere. And you better be prepared to go to trial if you're going to do that, and you better have the facts to go to trial if you're going to do that. Candor and transparency is key. I have insurance coverage up here. Call your insurance carrier when you get a subpoena, even when you get an access letter. Look at your D&O liability policy, your executive policy. I have insurance clients that issue specific policies to nonprofits. What is covered by a claim? Do they pay high-priced lawyers like me and Jeff, and we have to negotiate lower rates? Is there a carve-out for fraud or other allegations of misconduct? This is actually, I don't think I'm speaking out of school here. I actually think that this is something where regulators have a little bit of catching up to do in terms of negotiating settlements that involve bringing an insurance carrier in when you're talking about monetary relief, certainly, but they will catch up to speed. So call your carrier, briefing the board.
Wait, one quick point on that before we move on. It is really important because for nonprofits, the one policy that really varies wildly from carrier to carrier is D&O insurance. Most of the other policies that nonprofits have are pretty standardized: commercial general liability insurance, most property insurance. and other types of insurance are pretty standard. But D&O policies vary wildly, and some of them will provide coverage for governmental investigations, usually with some exclusions, and some will not provide any. They're more limited to just classic commercial litigations and lawsuits. And so you really want to, when you're shopping around for policies or your policy's coming up for renewal, take a look at that. It's a very important point.
That's absolutely right. It's 1:59. I'm going to leave you with one point. We've talked about the states being sort of the frontline regulators over nonprofits. We've talked about the IRS a bit. The Federal Trade Commission, I have had nonprofit clients say to me, the FTC doesn't have jurisdiction over us. The FTC can't touch us. That is a gross oversimplification. Well, first of all, putting aside charities, I mean, those of you who are members of professional or trade associations know full well that when you issue rules or bylaws that, for example, restrict truthful competitive advertising, dentists appear to do this a whole lot. I hope there aren't any dentists in the room, but the FTC is going, and this is California Dental, the FTC will come after you. But even charities, by statute, the FTC only has jurisdiction over entities that, over corporations that are engaged in commerce. So the default belief is, well, charities don't engage in commerce. But if the fact record makes it clear that the charity is in fact, not being run for supporting its purpose, but is instead being run for the personal and private benefit of either fundraisers or the founders, the FTC will take the position that it is a sham charity and that it does have jurisdiction, and the case law supports that. When might the FTC become involved? You're unlikely to hear from them first. You'll deal with the IL first, and she'll issue a subpoena, and you will provide, among other things like your meeting minutes, you'll provide financial information, you'll provide credit card receipts, and her office will go through your American Express statements and say, why did they go to Disneyland? Why did they go to Vegas? Person at the FTC, take a look at this, what do you think? Now you're dealing with the states and the feds. And that's when, I could talk for an hour about the proper strategy, and sometimes you want a big global settlement and sometimes you want piecemeal settlements, but it's not an enviable position to be in, and it is one that even the non-outlier CFAs of the world can find themselves in under the wrong circumstances. So anyway, I wish we had more time, but come talk to me later.
Thank you, Yael, for making the trip down to D.C. this morning. We really appreciate it. Thank you, Eric, and both of you for a terrific job. Thanks all of you for coming. If you have any questions here in the room in D.C., we'll stick around afterward. Feel free to come up. Otherwise, we hope to see you back here next month for next month's program. Thank you.